Larkins, and I am the president of the Fair Housing Center of the Greater Palm Beaches. It's indeed an honor to be here today, working in partnership with the Legal Aid Society of Palm Beach County and celebrating one of the most momentous events in the history of this country, and that is the signing of the Fair Housing Act, signed into office just 47 years ago. Many people don't understand that the Fair Housing Act is just not a law, but it's a civil rights law. It is a law that was passed only days after the assassination of Dr. Martin Luther King. Dr. Martin Luther King was assassinated on April 4th, 1968. The law was passed bipartisan way in Congress, signed by President Johnson on April 11th of 1968. That law is very, very important to us as we move forward and make sure that this law is a reality. For the law has the stains of Dr. Martin Luther King's blood, but not only Dr. Martin Luther King's blood, but also many people, black, white, Hispanic, Asian, and others, who have given their lives in order to ensure that fair housing become a reality. Now, most people believe that fair housing is a black and white issue. Fair housing is not a black and white issue. Fair housing is an issue that affects thousands of families throughout our country who have to go through the indignity of being discriminated against solely based on their race and color, solely based on their religion, solely based on their familial status, meaning presence of minor children under presence of minor children under 18. Solely based on someone's disability, solely based on someone's gender, or also someone's national origin. The Fair Housing Act is a comprehensive law that stretches throughout our society. Palm Beach County includes other ordinances that include marital status, age, sexual orientation, gender identity, or expression are all covered under Palm Beach County ordinance that also mirrors the federal ordinance that again protects race and color, national origin, religion, familial status, meaning the presence of minor children under 18, disability, and gender. These laws cover most housing. Any housing provider that controls 4 or more units, or if they do not control 4 or more units, but they fall within the category of that they advertise or lease with the broker, then they will fall within the Fair Housing Act. It's important also to understand that the law covers rentals and the sale of a home. In addition, these laws protect residents and consumers based on the fact that they're attempting to get a mortgage or someone attempting to get homeowners insurance. If you believe that you've been discriminated against, you should contact the Legal Aid Society Fair Housing Project or the Fair Housing Center of the Greater Palm Beaches. We're all more than happy to assist you. In addition, we'd like to reach out to housing providers in our community in order to ensure that housing providers are educated on their responsibilities under federal, state, and local fair housing laws. Thank you so much.
Good evening. My name is Sandra Powery. I'm a staff attorney at Legal Aid Society of Palm Beach County, Inc. And today I have the great privilege to speak with you regarding the Fair Housing Act, protecting the rights of the disabled. As Mr. Larkins mentioned, the Fair Housing Act protects certain classes of persons. The federal and state protects disability, race, color, sex, religion, familial status, and national origin. The Palm Beach County local laws protect sexual orientation, gender identity and expression, marital status, and age. Disability discrimination, who's protected? A person who has a physical or mental impairment that substantially limits one or more major life activities. A person who has a record of such impairment or is regarded as having such impairment. What is major life activities? This means functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. These are all major life activities to which the Fair Housing Act considers a person with disability. The examples of these disabilities would be visual disabilities, auditory disabilities, mobility disabilities, a person with AIDS and/or HIV, alcoholism, past substance abuse, and temporary disability from an accident or an injury. Who is not protected? Persons currently engaged in illegal drug use. Persons whose tendencies are a direct threat to the health and safety of other individuals. Persons whose tendency would cause physical damage to the property of others. Protecting your rights, the persons with disabilities consider for reasonable accommodations and modifications. What is required under federal and state laws? No discrimination against persons with disabilities in the terms, conditions, or privileges or rental of dwelling. When you consider reasonable accommodation and your request for a reasonable accommodation, it is considering the administrative change that removes barriers to have equal access. When you are considering reasonable modifications, it is a physical change that removes barriers, again, to equal access. When considering possible accommodations, some of those considerations would be to allow an emotional support or assistant animal on a no pet policy. Unfortunately, that is one of the many requests we have here in Florida, where the condo association may have a no pet policy. Another possible accommodation, allow the use of a scooter and or other mobile devices in common areas or in the complex. Allow a relative or a trusted individual to fill out application and make rent payment arrangements. Install mailboxes that are easily accessible for wheelchair-bound tenants. Offer another apartment to accommodate the needs and that does not cause inconvenience for other tenants. Allow a non-leaser to reside in complex to care for a disabled tenant. Install wheelchair ramps, a chairlift, elevators, remote control doors, etc. for a person with a disability. Place an open trash collection can in a location that is readily accessible to dispose trash. And assign accessible parking for handicapped tenants. When you are considering reasonable modifications, these are changes to the physical structure of the unit. These would include modify the unit's entryway to widen the doorway or reverse swing of door, install mailboxes that are easily accessible for wheelchair-bound tenants, remove cabinets under the sink, place an open trash collection can in a location that is readily accessible to dispose trash, install wheelchair ramps, chairlift, elevators, remote control doors, etc. Modify switches, lower the thermostat controls, or light switches. When you're in a wheelchair, sometimes those things are no longer accessible. Modify door handles, change doorknobs to levers. Altering a walkway to provide access to a public or common use area. When considering reasonable modification, a housing provider may require the individual to return the dwelling to its original condition. This only applies if the modifications will interfere with the next tenant's use and enjoyment of the premises. Housing providers has the right, a housing provider has the right to condition permission for the modification based on assurance that the work will be done properly. So some type of licensed contractor must do the work. Ask the individual to obtain any necessary building permits. Ask the individual to set aside a reasonable amount of money over a reasonable time in an interest-bearing escrow account to pay for the restoration. When a person with disability is making a request for a modification or for an accommodation, the request for accommodations should be made in writing. There must be a nexus between the disability and the requested accommodation. And the term nexus is a connection between the disability and the reason for the accommodation. The housing provider has the right to ask for verification if the disability is not apparent. The request must be reasonable. There are certain medical information that can be requested. A housing provider cannot ask if the person has a disability or the nature or severity of the disability. However, the provider can ask the following if asked of all applicants. The applicant's ability to meet tenancy requirements, whether there is a current illegal abuser or addict of controlled substance, whether the applicant qualifies for a dwelling legally available only to persons with a disability, whether applicant qualifies for housing that is legally available on a priority basis. If both the disability and the need for the accommodation or modification are obvious, the housing provider cannot make further. If the disability is obvious, but the need for the accommodation or modification is not, provider may request only information necessary to evaluate need for the accommodation and or modification. If the disability is not obvious, provider may request information necessary to verify that a disability exists, describe the needed accommodation/modification, and show relationship between the disability and requested accommodation/modification. The medical information provided cannot require this information be given only in a certain format, such as a questionnaire or an affidavit. It can merely be a letter from the person who is requesting the accommodation. It can be a letter from their medical provider. Sometimes a housing provider defense against giving a person with disability the accommodation or modification can be that the request causes an undue burden, which means that it can be unreasonable financially or by way of administrative cost. The fundamental alteration The request poses a fundamental change to the housing provider's basic operation or nature of services provided. Again, these are defenses to which a housing provider can deny a person's modification or accommodation based on undue burden or a fundamental alteration. I want to speak to you about service animals and emotional support animals, because here again in South Florida we have many requests for a service animal or emotional support animal, also known as ESA. Service animals and emotional support animals are not pets. They provide a service or a benefit to a disabled individual. Service animals and ESAs are not required to have specialized training, licensing, or certification. Example of service animals are seeing eye dogs or even horses, hearing dogs, helper monkeys, seizure assistance alert dogs. These are all examples of service animals. ESAs provide a therapeutic benefit through their very existence, companionship and affection, a focus outside oneself, encouragement to be physically active by going for walks. Any animal can potentially be an ESA animal or ESA. Dogs, cats, birds, fish, etc. It really is based on an individual basis. I hope that we were able this evening to provide you with your understanding of the Fair Housing Act and the opportunity for you to know your rights. One of the handouts includes where you can turn for help. Obviously, you can come to the Fair Housing Project at Legal Aid Society. You most certainly can turn to the Fair Housing Center of the Greater Palm Beaches. Locally, we have the Palm Beach County Office of Equal Opportunity, to which that program and agency has the opportunity for a person to go through the process without the assistance of an attorney. You also have the U.S. Department of Housing and Urban Development and the Florida Commission on Human Rights, which we provided the contact information for you. But because the Fair Housing Branch Project of the Legal Aid Society and Fair Housing Center of the Greater Palm Beach Counties are two agencies that certainly can assist you, we hope that you would turn to our agencies first. Thank you.